Hello, everyone, and welcome to our Insight Sustainability webinar of the DRBF Region 2, Climate Change Disputes and Green Dispute Boards. I'm saying Region 2, but our guest speakers are the President-elect of the DRBF, Jeremy Glover, and a guest speaker from Region 1, Patricia Galloway. I am Georgiana Tekuc, President-elect of the DRBF Board of Directors Region 2, and I'm your host for today. For those of you who are new to DRBF, and I've seen some new names today, the Dispute Resolution Board Foundation was established in 1996 by the creator of the dispute board process, with a mission to develop dispute avoidance and effective resolution for construction projects. Today, the association has over 1,400 members in over 70 countries, as the dispute board process has expanded worldwide and is now used on a wide variety of projects and long-term contracts of many types and sizes. The DRBF develops best practices and offers training and educational resources for project owners, contractors, and DB practitioners. And it also partners with other industry organizations to adapt the DB process to new sectors. It may be of interest to know that DRBF is publishing a guide to best practices and procedures, the DB manual, now available in English, French, Spanish, and Portuguese. And today we are going to find out what climate change disputes are all about and whether the dispute boards are ready to deal with such disputes. As I said, our guest speakers, Jeremy Glover is the President-elect of the DRBF and a partner at Fanik Elliott. He is a member of the FIDIC Net Zero Task Group 23, a member of Chancery Lane Project, Built Environment Advisory Group, and a member of the ICC UK Sustainability Committee. Jeremy will introduce us to what is meant by sustainability and will help us uncover what to do and what contracts say about it. Dr. Patricia Galloway is a civil engineer and a chartered arbitrator, a DRB member and a mediator with over 40 years experience. She's specializing in energy and construction matters. She's a fellow of the CAA, CRB, and a member of NADN and the DRBF. She also holds a climate change leadership certification from the Diligent Institute. Dr. Galloway is a member of several arbitral institution panels, including the ICDR AAA's Commercial Energy Construction Large Complex Case and Mega Projects panels, as well as CRB, LCA, USCIB of the ICC, and the CPR's Cross-Border Energy and Construction panels. And Patricia will tell us what type of climate change disputes we might see and what can the dispute boards do to encourage a greener approach. This being said, Jeremy, do you think the dispute boards are ready to deal with disputes arising from sustainability issues?
Always, always ready. I mean, and I think that's an important thing to actually think about. Dispute board members should be experienced construction professionals, and what we're effectively looking at are potential disputes or ways to help the parties move the project forward relating to issues arising under the construction contract. So a construction professional will understand the basics, but some of the issues will be new. And I know that I will touch on one or two things that I think dispute board members need to talk about, be thinking about when they're looking at these new disputes. And I'm sure the same will be the same with Patricia. So as Georgiana has said, these are the issues that we're going to look into this evening. And I apologize that my computer isn't working properly, so Georgiana will be has drawn the short straw and will be moving the slides on for me. So I'm going to look about what we mean by sustainability and look at one or two examples of what the standard form contracts actually have to say. Now, like many of these definitions, sustainability, well, what does it actually mean? So I thought, well, one example, let's have a look at the 17 United Nations Sustainable Development Goals. Now, these represent a 15-year action plan to end poverty, protect the planet. The idea is you don't leave anyone behind. And many of the projects dispute boards dispute board members are working with today, they're going to be underpinned by many of the sustainable development goals. Many of the projects are going to be funded by the development banks and similar funding agencies. But I suspect we don't all immediately think about these goals when we're actually thinking ourselves to define sustainability. We might look at number 11, sustainable cities and communities. We might think about number 13, climate action. But I think there's a lot there within those goals themselves that we need to be thinking about. But on the next slide, I mean, we're looking at net zero. People think about sustainability. United Nations definition from the Net Zero Coalition. Net zero means cutting carbon emissions to a small amount of residual emissions so they can be absorbed. And that's the type of thing I think that people are thinking about when they talk about sustainable development. There's a definition there of sustainability from one of the UK contracts, a framework agreement, reducing carbon emissions, but also reducing the use of energy or man-made resources, looking to improve waste management, improve employment and training opportunities for people, protect the environment and the well-being of people. Now, I think that's sustainable development along the lines of the UN Sustainable Development Goals and what most people would think about as sustainable development. You can get too hung up on the carbon emissions point, which is why I've also talked about retrofitting. What are the alternatives? What actually applies and is most relevant to the area where the work is actually being carried out? Now, retrofitting is all about introducing new materials to existing buildings, not demolishing what's already there, but seeing how you can make use of, maybe even, I suppose, recycle what's already there. So we're looking at, on the next slide, green construction, sustainability, processes that are environmentally responsible, thinking about a building's life cycle. So there's changes perhaps to how dispute boards work. You've got a typical construction project, you start the contract, you finish the contract, everybody moves on. As I'll come on, I think when you're looking at things from a sustainable point of view, the life cycle of a project is far more important. But you want to design and construct a building to make as little impact on the environment as possible. So, and why that becomes relevant and why that's relevant to can a DB actually operate successfully on a sort of, if you like, a green project is because there are going to be new methods of construction. There are 4 key purposes on the next slide of dealing with sustainability: reducing energy loss, reducing carbon, reducing pollution and weight, and conservation. One of the reasons that you want to adopt a sustainable approach is to preserve what we actually have. So yeah, we're talking about achieving net zero, but that's only part of the picture. The bullets on this slide, I think they're a mix of issues, reducing energy and waste. And that leads into this concept of recycling. And I really like, on the next slide, this idea of build nothing, build less, build clever, build efficiently. Do we actually need, before you actually start a construction process, do you actually need to build a new building? How can we maximize the asset which is already there? And if we are going to build, let's build clever, let's build efficiently. Construction engineering firms are great. They've got always bursting with new ideas to actually build efficiently. And what's interesting about this idea is that it's 10 years old, and it even comes from the UK government, who seem to be stepping back from sustainable issues at the moment. So it's 10 years old, and they had the right idea. They were looking at recycling, looking at retrofitting. And it's, to me personally, staggering that we are where we are in the UK, but we're not talking sort of green products, we're not talking sustainable products. It's the idea that when we're talking about sustainability, don't get necessarily too hung up on net zero carbon emissions. It's very important, but it might not be appropriate in the area where the construction is actually being carried out. And if you look, you probably can't see because the slide's quite small, but the bottom of the slide talks about planning, design, construction, commissioning, and operations and maintenance. That's the whole life cycle of a project. And that's on the next slide. And I think that is going to be one of the changes that we will see, not immediately, but operating on a more sustainable premise. What matters is everything from day one, the concept, all the way through the use, the construction, and then possible that, you know, even the demolition and sort of reuse and recycling of the project that's already been there. So that's a very long period. You know, I mean, these projects are meant to last 20, 30, 40, 50 years, but it's all about, you know, operation of a building. And I think the handover might change. There's a softer handover from construction to operation. There may be more scope for dispute boards to be involved in projects for a longer period. Might be extended handover period. You know, I know there are design, build, operate contracts, but I think even your standard design, build contracts are going to change. The question of biodiversity, the UK has just introduced a mandatory scheme requiring that projects have a net biodiversity gain of 10%. The idea is that habitats for wildlife are left in a measurably better state than they were before the development. Now think about that. The key word there is measurably. How do you measure a net biodiversity gain? How do you say that the habitat has got 10% better? Now, a way to do that is to employ experts who can do that, but it's a new skill. It's something else that you may need to be aware of. And so it's the kind of thing that you're going to find introduced into some of the contracts. I'm going to very quickly look at 2 or 3 of the standard forms. The JCT form is a UK form, it's the standard UK contract. They have an optional clause that talks about a contractor being encouraged to suggest economically viable amendments to the works. Now, it's all quite vague. It's not very mandatory language. And one of the reasons for this is we're talking about new concepts, whether it's net biodiversity or whether it's using different forms of materials to reduce the carbon elements of the work. They're new. People don't necessarily know how well they're going to work. So there is a school of thought, well, let's not have mandatory elements. Let's work in a more collaborative way forward, which is, you know, what dispute boards are all about: collaboration, conflict avoidance. So that's one way. JCT might be changing all that in a couple of weeks' time when they release their new contracts, and they're going to, the word on the street is that they're going to move these optional clauses into the main contract, and there may be more of an element of mandatory or prescribing that a contractor does something. And with the NEC form of contract, again, based in the UK, but much more global impact, Hong Kong, South Africa, Peru, and other places around the globe. And they have an optional clause, X29. They allow the parties to have their own climate change requirements, and they have a performance table. And then there's an either or. You can go for the not mandatory performance, or you can agree financial incentives. So it's 2 options, because, you know, one of the things that you might want to be thinking about doing, you set targets, you set goals, and you want to reward innovation. A standard approach, there's an example of a New Zealand standard form of contract. It came out last year, doesn't really mention the idea of carbon emissions. It talks about a contractor taking steps to ensure there's no contamination, to follow the local regulations, and to, you know, be careful about if there are any enforcement proceedings. Now, that's a fairly standard set of things you might find in a construction contract. You're a DB, you come along to a contract, and the contractor must follow the local regulations. You know, they must take heed of any enforcement proceedings. So again, it's not a new issue. What is new is it's a new type of issue. It's a new approach. And the New Zealand approach is fairly typical to the more standard FIDIC approach, which you currently find in the 2017 form of contract. Up there, 4.18, protection of the environment. Mandatory contractors shall take all necessary measures to protect the environment. Well, what on earth does that actually mean? And that's a particular, but that's an issue that you have to grapple with as a dispute board today, and you may have been grappling with it prior to that. But as we know, FIDIC are looking at alternatives, and so where might FIDIC actually be going? Well, if you're able to attend the FIDIC Contracts Committee, FIDIC Contracts Conference in December of last year, there was a clue. And FIDIC were concentrating on carbon emissions, the idea of a carbon budget, i.e. working out that the project was going to have carbon emissions of a certain value, and then perhaps a contractor would try to ensure that the emissions were kept to that agreed budget. There's a reference to incentivizing the contractor. Well, perhaps there might be a sort of pain gain type share type arrangement, but that's still under discussion. But FIDIC's focus is there, partly on the idea of the carbon emissions budget, and also partly on a how-to guide, because you have a budget, and that suggests there are figures, but how do you measure? Who does the measuring? Who understands what the results of the measuring actually are? And that might be where the dispute board is going to come in. And if you're looking for examples of potential clauses, go to the Chancery Lane project website, search Chancery Lane projects, you'll find that very easily. And there's a series of contract clauses on the slide at the moment. There are ones for the UK, and they talk about net zero. They talk about sustainable on-site working practices, benchmarking greenhouse gas emissions, using construction materials. Now, from a sustainable development point of view, one way to use, one thing you might be doing is looking to use innovative materials, which perhaps have less carbon in. But also, if you're acting from a sustainable development point of view, you might want to be using local materials, benefit the local economy, and far less transport costs. And so the Chancery Lane project doesn't just have clauses for the UK. They also have contract clauses for the USA. The same idea, you'll find the clauses, they all have a child's name. And the good thing about these clauses is they are subject to peer review from a number of people within the construction and the legal industry. So there's been a lot of thought that has gone into them. You see the USA clauses, there's one about sustainable soil management, and there's one about setting up a formal carbon budget. But then look at an example here. This is the Tristan's clause, it's the UK clause, and they've set up a carbon budget, and it's very simple. The contractor is required to carry out the work so the carbon budget is not exceeded. And then from a DB's point of view, all that might matter is, has that budget been exceeded or not? So again, that shouldn't be too difficult to work out, because hopefully there'll be some kind of agreement as to how the carbon or the greenhouse gases are actually being measured. And if you're a dispute board, the most important thing you then need to do is make sure that you actually understand the basic concepts behind the measurement. And to me, this is a potential, you can't just simply drop Chancery Lane project clauses into contracts. You need to think about them. This one talks about liquidated damages levied against the contractor if they fail to, if they go over the budget. Well, what about a potential incentive for the contractor to do better? So, the NEC approach talks about potential financial incentives that could be agreed with the contractor. So there's lots to think about. These are new ideas. People are being asked to work in new ways. So there does need to be some collaboration and trying to work out the fairest way forward. And another problem that you may see with these green clauses, and there's an amendment proposed to the JCT clause here. It talks about an obligation to comply with environmental requirements. Again, it talks about protection of the environment. It talks about sustainable construction and development. But what does that mean? And from a dispute board point of view, I think quite often you'll be faced with contract clauses that are like that. But this clause, it specifically refers to an annex of environmental requirements. So the devil is going to be in the detail. You need to dig down. You need to be able to perhaps understand what those specific requirements actually are. So again, in theory, well, dispute boards, well, we do that all the time. Quite often the real dispute or the real point of issue between the parties, which we're trying to find a sensible way forward so we avoid a dispute, is tucked away in the technical requirements. And when you talk about construction professionals, they understand basic how the technical requirements work. So there may be education needed here to understand how the particular environmental requirements actually work, because there will be green clauses, there will be sustainable clauses in these contracts moving forward. The World Bank has introduced rated criteria from September of last year. Most people on this webinar will know that. That's to help borrowers achieve sustainable development objectives. It's to better manage environmental, social, supply chains. They're all about sustainable development. You will find these issues set out in the contracts. To go back to a UK example, the construction playbook, that talks about the source and usage of sustainable products and materials. Interestingly, from a dispute conflict avoidance point of view, they're talking about a core group, and it's not just the employer and the contractor, it's a wider group. Consultants, supply chain members, they're managing the risks, but from a sustainable point of view, there's a wider group of individuals and companies and potential project team members who are involved. And so that might in time lead to a different approach. I've put an example of the conflict avoidance boards from an essay from a couple of years ago. And it talks about mutual facilitators, and it talks about parties developing realistic options to deal with projects and issues arising, which is exactly how a dispute board would work. And it talks about the non-adversarial mechanism. And in many ways, sustainable issues arising in relation to sustainable development, they're crying out for dispute avoidance or conflict avoidance because they're so new. And so you need to find the right way forward. But, you know, this guy's talking about providing a platform for the exchange of a wide variety of views. On a dispute board, when they're looking to engage and operate dispute avoidance, conflict avoidance, will be doing that. So is there a new role for the dispute board? You're going to be dealing with climate change issues. They may be contract provisions. They may be in the scope. It's more likely to be a mix. And we can all read the contracts and we can all understand them so far, but there will be a need for some education. And it's not just the contract. You need to be aware or ensure that the parties are informing you about what are the regulations and what's the legislation which applies. And do you understand the new concepts? You don't need an in-depth understanding, but like anything, any part of the construction contract, you need to understand how these things operate. So it may be that as part of the first site meeting, you'll have some new, I've called them green requirements. If there's a budget, the two most important things are to understand how the carbon budget works, and if there are other environmental targets, how are they going to be measured and who's going to measure them? We're looking at, you know, it's all about transparency. And again, that's nothing new, but you do need to sort of get a grip at the outset. And as I've said before, I mean, you've got to understand how other parties to the contract are actually fitting in. And in time, you may see green checklists. I mean, as to what should dispute boards do now, Something you might want to think about is terms and conditions. Talked about pre-qualification of contracts and the idea of the introduction of the World Bank, they're not just going for sort of cheapest price, but it might matter what's on a DB's terms and conditions. I mean, how green are there? Have you acknowledged sustainable issues as part of your terms and conditions? Do you actually need to do that? And I think as a sort of final point, and a sort of final takeaway point, this concept idea of meetings and site visits. And as a result of COVID, we all became very good at virtual hearings, virtual site visits. And I do think now there is a potential tension between, do we go for our regular site visits every 3 months? Should we actually cut back on that? And one reason that is cited to do that is green issues and sustainable issues. And one of the things that I've learned from working on FIDIC TG23 is that the carbon footprint of a DB is minimal when you take into account the overall carbon footprint of a particular project. And so where people are saying, if they do, that we don't think we need as many regular site meetings, and because we're concerned about the carbon footprint, think why that is really being used. Because from a dispute board point of view, the most important role of a dispute board is conflict avoidance, it's dispute avoidance. And the best way to practice that is to be able to go to have face-to-face meetings, to be able to meet the people, talk to people at the site visits. FIDIC have acknowledged this in their Rule 3.3 for meetings and site visits. Each meeting should be face-to-face and each site visit shall be in person unless the parties agree that exceptional circumstances mean that they shouldn't. And that's because FIDIC want to promote dispute avoidance. And I think that's something that the DRBF always wants to do. And so sort of my final point is, might sound slightly surprising, having spent 20-25 minutes extolling some of the virtues of sustainable development, and there were a lot of virtues of it, but you shouldn't let green issues be used as an excuse to avoid face-to-face site meetings and visits. So they were all the things that I sort of wanted to talk about for you today. Thank you, Georgiana, for moving on the slides expertly. And so I think there'll be questions at the end.
Yes, we'll take questions at the end. And now I'll invite Patricia.
Great. And I'm assuming that you're allowing me to share my screen, yes?
Yes, please, unless you want me to do it.
Can you see my screen now?
Not yet.
Okay, I am sharing it. You can't see it? It's
Not
up on
yet.
my screen?
You need to double click on it and make sure it's in slideshow mode.
It is.
I cannot see it. Jeremy, do you see it? Or any of the participants, can you see it?
No, I can't see anything. I can see you.
Okay.
Well, it's on my screen, so if you can't see it, then I guess you're going to have to do the same as you did with Jeremy, unfortunately.
Here we go.
All right. Well, let's see how that goes. Thank you very much. And thank you, Jeremy. It was a great for you to give me that little introduction. I think it helps a lot. So what we're going to do, as we see on the next slide, I like to put up this little sign that says, if not now, when, because there is no planet B. So I think that that's very apropos as we look at the disputes that we might see. So moving on to that. So there is a Sabine Center for Climate Change, which is part of the Columbia University in New York City, and I would highly encourage you to go to their website if you're not familiar with it. They have really assisted everybody that is in this legal world relative to climate change litigation, not only for the data, but there's actually all the case law is on their database that you can look up. You can see the trends on what types of disputes are winning, what are losing, and maybe why. And even if you don't follow all of that, it certainly heightens your awareness of what you should be aware of that is actually out there in the litigative world. And so based on that review and looking at their trends, there are 6 big trends in the climate change litigation. They involve around climate rights, enforcement, keeping fossil fuels and carbon sinks in the ground, company responsibility, climate disclosures and greenwashing, and failure to adapt and impacts to adaptation. And as you can see there, per the Sabine Center for Climate Change, as of December 31st, 2022, there were over 2,100 cases and filed in 65 jurisdictions with about 1,500 in the US alone. So as we look at the next slide, while there are 6 key trends that I talked about earlier, I'd like to focus on 4 that are specifically applicable to the energy and construction matters. So if we look at climate rights, what does that mean? And Jeremy talked a lot about this relative to the UN, the Paris Accord. Many governments are mandating that companies have certain goals, certain states or provinces within a particular country have certain carbon net zero commitments that are now mandated in legislation. And so you are seeing a lot more third-party lawsuits being filed in the area of these commitments not being met, or governments not including in their contract or undertaking the efforts that they need to protect citizens from climate change. So that's what we mean by climate rights. If we look at enforcement, what we're seeing is, I will give some examples of this as we go through here. You have existing legislation. You've seen a lot of the existing legislation that Jeremy has talked about in the UK, in the United States. We also have, clean air legislation. We have our Environmental Protection Agency legislation. And so folks are taking some of that legislation and extrapolating that into climate change issues for which they are also filing disputes. The other area that we see, and I sit on 2 corporate boards, and so in the public arena in the United States, and also as it is in Canada and Australia and the UK, you see that there are a lot of expectations and there's regulations. Here we have our SEC requirements that have just recently come out on climate change and what disclosures company must make, and what disclosures they must make is how they are trending and how they are making commitments. And if you provide commitments and you do not meet those commitments, and or you provide false information that may not be true, or you may not meet that information, you then face some issues, not only by potentially the SEC, but also by your investor base, because what do we do with public companies? They invest money based on those commitments. ESG is now coming to the forefront in public corporations. And a lot of the major investors, such as BlackRock and some of the others, are really looking at what companies are doing with their sustainability reports and what they're doing in this area. So it is also becoming a much, much larger focus in the public arena. And then lastly, we have the failure to adapt, and this will be a primary area that I'll be focusing on relative to dispute review boards. And that is the failure to not consider the impact of future climate change in designs, but we're also going to see how that impacts architects and engineers, constructors, and owners. So what is that? So if we move to the next slide in considerations, I'd like to first talk about what the impacts are to the architect and to the engineer. And this is going to be a key area that I think the dispute review boards will be faced with on many of the projects going forward, whether that be buildings or heavy civil. So Jeremy touched on this. He talks about the contracts. There are also statutes. There's regulations that may impose particular requirements on the architect and the engineer. So it's really, really important that any architect or engineer entering into a contract with an owner not only looks at their contract to fully understand what those clauses may be, but also be fully aware of the statutes that are going to apply because they will be binding upon you. Also to look at the regulations that may exist in a particular jurisdiction, because those will also be mandated upon you, and they are changing rapidly. So be careful as to what your contract says your responsibilities are under your term of your contract relative to those changing regulations as it relates to climate change. Further, the American Society of Civil Engineers and the Canadian Engineering Qualification Board have also now published standards for engineers to adapt to climate change. Engineers need to be fully aware of their standard of care provisions. A standard of care clause is typically included in all design contracts, and compliance with local codes does not insulate that design professional from liability if your peers are building to higher standards, because remember, under a standard of care clause, you will be judged according to what your peers would have done under the same circumstances at the same time. So it's very, very important to stay abreast of what all of this means. Then the contractual requirements for meeting green energy goals. Again, Jeremy talked upon some of this, and I am, for instance, sitting on a DRB right now as the chair on a very, very large building project. And I was quite interested to see the number of clauses that have been incorporated into that contract, not only relative to LEED, which is our certification, for green buildings, but also an entire section entitled sustainability and what that means relative to materials, what that means is relative to conduct of how the operations will be and execution of the project will be carried out. It's quite long, it's several pages long, and it just speaks to what Jeremy was laying out and what we are seeing in not only are the countries mandating certain legislation, but you're now seeing a lot of those provisional and may clauses now becoming binding within the actual articles of the contract. You're also seeing consideration for future climate change impact over the design life of a project. You saw Jeremy's chart with design, the life cycle of a project. Engineers now need to consider that they may potentially be held accountable for having the ability to foresee what some of those impacts may be for their region, for their area, such as coastal projects. Have they looked at what the percent of sea rise is, for instance, over the life of that project and how that may impact? How they have looked at severe weather and how that could impact the actual building or heavy civil project, and have those considerations gone into the life cycle considerations that they will be responsible for. So for instance, there's an example there at the bottom. There was a new LNG facility where the initial environmental impact assessment did not consider the GHG emissions for the entire lifetime of the facility. And that resulted in some disputes over that. So moving right along to the next slide, when I indicated that it's not just the architect engineers, but also contractors. So contractors have to also be, well, they will assert that their job is only to build to the plans upon which they were given, of course, unless they are a design builder, and that they may face issues, though, which do relate to their means and methods. And I want to give you a really interesting example that happened in the United States a couple of years ago, and this is also on the Sabine Center case study. And that is a case where in Florida, Skanska was doing a rehab of a bridge, and there was a destruction of a protected bridge that failed during a severe hurricane, which severely damaged the bridge. And that went all the way through litigation, and Skanska was held responsible for not planning appropriately, noting that they should have been aware, because of climate change, of the severe occurrence of hurricanes, and that was not necessarily a force majeure event, and they should have planned it accordingly. So it is now shown to be real. And so this is where contractors, if they fail to adequately plan for the consequence of extreme weather events, need to know that they might be held accountable. Okay, moving on to the next slide. Again, it's not just the architects and engineers, and owners are not immune. And while claims are typically filed against owners that are raised by third parties that I talked about earlier, they potentially can have knock-on effects on delay and cost impacts if such claims arise after the contracts have already been signed. There also may be opportunities for new construction projects based on the demanding oversight of these new projects. I think that you will see more requests to make sure that you have dispute review boards so that they can provide the necessary oversight and be in a place to help the parties, especially with advisory opinions, which I'll talk about in a little bit. But I just wanted to give you three examples here where owners have faced climate change issues. For instance, in California, this has gotten worldwide attention on Pacific Gas and Electric, which is the largest public utility in the United States. And the government approvals were challenged based on the project's inconsistency with the Paris Accord and/or country state net zero commitments or climate change stated in their EIA. And of course, with the fire that basically destroyed one major city, and I think they are now putting 50,000 miles of underground utilities, which they have embarked on at about a $13 billion cost. Another is in the Court of Appeals, the Civil Division of England and Wales, in Client Earth versus Secretary of State, which is a more recent case in 2021, where the government declined to address whether the conversion of power plants from coal to natural gas ignored UK's net zero targets. And that's something that Jeremy talked about, and there's a real life case that resulted from that. The other is in Texas in the United States, the Texans against high-speed rail versus the United States Department of Transportation. And it was approval of a rule of a particular for a high-speed rail technology proposal for Texas, which failed to consider how the potential rail project would account for increasing rainfall levels resulting from climate change. So again, another example of things that you may not expect, which are becoming more prominent. So with that, if we move right along to the next slide. And so what are some of the things and issues that are currently arising out of these disputes, to which dispute review boards are going to be faced to hearing, and which either will assist the parties in making determinations on claims that arise? For instance, net zero. Drivers to net zero are not just financial or technology related. Jeremy touched on materials. This may be how they're spec'd or how they may be used might generate disputes. There are renewable energy projects, batteries, and transmission that are going to include materials that will speak to this. There will be zero emission vehicles or hydrogen powered trains that will speak to this, but they're also, with the decarbonization of buildings and public infrastructure, we're looking at now at energy efficient HVAC, we're looking at low carbon steel, we're looking at low carbon cement, and all of these are often being mandated in contracts and or being suggested by contractors as part of some of the green sustainability clauses in the contract. The other issue is the first of a kind technology to support green energy projects. This involves either unproven technology or equipment scaled up to size, not in commercial use, the integration of commercial technologies to a new use or a new industry, the integration of first of a kind components into commercial applications, and logistics and limits on equipment and vessel availability. And so all of these mechanisms that are being used to support green energy projects, the DRB needs to recognize that you're going to see more subject matter experts that are not just your delay or quantum experts, but are going to be experts in climate change impacts. And so you need to be aware that you're going to start seeing more of that when you are in your hearings. So moving on to the advisory opinions, this is something that is available for all dispute review boards, but not used as often as I personally think it should be, and how helpful it can be to the parties. So considering about what we have talked about so far and the type of climate disputes that might arise, so what would be the type of advisory opinions that might assist the parties as the project moves forward? Well, first of all, if it does have net zero targets, or it's in a jurisdiction where it's mandating such net targets, how are those going to be implemented? I mean, Jeremy talked about that a little bit on the DRB's need to understand that and to fully understand it. And it's extremely important because the DRB needs to address that with the parties early on, maybe even at the initial kickoff meeting. The other items that I see that are critically important for an advisory opinion is, what are the obligations of the state or the owner under law and regulations to ensure the protection of the climate system or other parts of the environment for present and future generations? That life cycle that we talked about. I think it is extremely important to make sure that the parties fully understand their obligations under the contract, the statutes, and the regulations, and how the dispute review board might help the parties in that. And what are the legal consequences under those obligations where their acts or omissions cause subsequent harm of the climate system? Are we going to see third-party claims come in, which during the course of the project? Are we going to see the owner file claims against the architect, engineer, and/or contractor for not following their obligations? But wouldn't it be nice if the DRB could at least establish early on what those obligations are and what through the contract mechanisms would be the consequences if they're not met? And that goes to then how we interpret those contract clauses to assist the parties in their intent and meaning. Something that I'm seeing more of on the dispute review boards that I've been sitting on is where the parties will literally ask the DRB to come and tell the parties what their interpretation of the clause is to assist them going forward throughout the project. All right, so if we then move on to the next slide, we will see that we get to the point of finally, as Jeremy was talking about, how can dispute review boards encourage a greener approach in their role of a DRB? And something that I think and agree with Jeremy that should be addressed very, very early on at the beginning of the project. So let's look at what those are in the next slide. So first of all, there is no need to reinvent the wheel here, as thanks to Lucy Greenwood's hard work in this area, and clearly was and continues to be a leader in the disputes world for a greener approach. And she has developed a pledge, which any of you, if you were interested in signing on to, can certainly go to her website and do so if you're inclined. But even though she has quite a plethora of ideas and suggestions of how litigation and arbitrators can be and dispute review boards more greener, what I've tried to do is take the key areas where I think the DRB can actually make a difference. And sorry for repeating some of what Jeremy has said, but under some of the sustainability issues, if you are meeting, or even if you're in your own area to try to use clean energy and reduce energy consumption, encourage your parties, including yourself, to minimize the use and printing of paper, to, of course, encouraging recycling wherever you can, to limit the use of single-use items and plastic, of course, that travel responsibly. One of the things that I would like to suggest in our area of technology today, the cameras and the 360 drones have made a great difference relative to the ability to be able to walk and see the project. And so I have been encouraged that a lot of our meetings, we have not had to have site visits because they have provided the opportunity to show us the site in probably a lot more detail than we would have ever been able to see if we had actually made that site visit. That's not to say that that you shouldn't continue to periodically go to the site, whether that's twice a year, once a year, but with the other technology, you probably don't need to be at the site every 3 months, which goes to the carbon footprint savings. Favor electronic communications, if at all possible. Use electronic tools to annotate your documents instead of printing them out and writing notes. And that goes again to that carefully consideration of, do I really need to print this or not? What do you have to maintain? You know, typically you as a DRB are asked to maintain records for a certain period of time. It's obviously a lot greener to maintain those electronically versus in hard copy. Ensure that your submissions are also served electronically to you. It's much easier these days to do that versus having many papers and mail sent, and then encouraging your video conferencing versus travel. So those would be the key areas that I would see that we can encourage the parties, and you might do this at the kickoff meeting to, again, just remind everybody that we are in this greener approach. And especially if you have a contract where I just mentioned, where there are pages of sustainability efforts to be undertaken within over the course of the project, you as a DRB have the same responsibilities to try to keep that as green as possible throughout your tenure as a dispute review board member. And with that, I think we have about 3 or 4 minutes for questions.
Yes, we do. In just a second. I noted that you answered a couple of them already, but I see there is a question from Lorenzo Tomasini for Jeremy. In your opinion, is it possible that the DBs, properly integrated with experts with an environmental background, will play a role in the prevention of environmental damages in the construction projects? Jeremy?
Well, it's certainly possible. And the way that it would be possible is that the person asking the question has talked about experts. I think that's quite important. But I mean, the idea of a dispute board is that they work with the parties to try and mitigate problems. So where problems or issues are brought to their attention, they can certainly, particularly where they've managed to develop an ongoing relationship with the parties, they can look to see how they can help mitigate those issues. So I think the answer is potentially yes, they can.
We can't hear you.
Oh, okay. Can you hear me now?
Yes.
Yes.
Okay. I thought I've seen another question in the chat, but I'm not sure. So I don't think we have another one. I've seen Patricia answered questions from Moen and Anil. So I guess everybody has seen the answers. If no one has any other questions, I guess we will stop here. Does anyone have any more questions? Oh, well, thank you very much, Patricia and Jeremy, and we look forward to ask some more questions next time from you. Definitely interesting to hear how these are going to evolve. It's quite exciting, especially hearing that the MDBs are now introducing more and more environmental obligations. They had some in the past, but now they seem to be more strict about imposing them to the states, and especially when we talk about grants and loans. So again, thank you very much indeed, and looking forward to talk to you again.
Thank you very much. And thank everyone for attending.
Yes, no, thank you all very much. Much appreciated. Cheers.
All right. Thank you. Bye.